of its membership and in terms of the number of states parties to the convention. In closing, I realize that you are fully dedicated to the session that will follow. I wish the participants very happy and productive conference. Once again, thank you, and I'm delighted and honored to have this opportunity to welcome to you the role of the Hague Conference on the Private International Law in the Private International Law Development Indonesia. Thank you. Wassalamualaikum warahmatullahi wabarakatuh. Shalom. Om Santi 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 Om. Namo Buddhaya. Salam kebajikan. Sampurasun. Terima kasih.
Thank you.
Thank you to Mr. Leona. Next, we will begin today's conference on the role of the Hague Conference on Private International Law in the Private Commercial Law Development in Indonesia.
Before we begin today's conference, we would like to introduce our moderator, Mr. John Lumbantobing, Bachelor of Law, Master of Law, FCRB. He is the Vice Dean for Students and Alumni Affairs, Faculty of Law of Parahyangan Catholic University. He is also a Fellow of the Chartered Institution of Arbitrators and the Secretary General of Indonesian Academic and Practitioner Association of Arbitration.
His bachelor degree had been completed in the Faculty of Law of Parahyangan Catholic University. His master's degree had been done at the University of Cambridge. He is a researcher in private international law and law of contract. One of his most notable publications is Indonesian Perspective on the Hague Principles of Choice of Law in International Commercial Contract, that is co-authored with Dr. Bayu Seto, in a volume edited by Professor Daniel Giersberger et alia, published by the Oxford University Press. To Mr. John, the floor is yours.
Good morning, everyone. I'm very happy to introduce and moderate this session. And I suppose it's now my turn to call upon the panelists for this session. First of all, we have Mr. Christoph Bernasconi, who is the Secretary General of HCCH. Christoph, would you? We also have Pak Amri Jinang, the Director General of Law and Treaties at the Ministry of Foreign Affairs. Amri. And then we have Professor Budiono Kusumo Hamijoyo, who is the Professor of Philosophy of Law here at UNPAR. And also, just like Pak Dekan, Prof. Budiono is also my lecturer. And lastly, Pak Bayu Seto Harjono, former Dean at the Faculty of Law of UNPAR and President of the Asosiasi Hukum Perdata Internasional Indonesia. For this session, each panelist will present for roughly 20 minutes. Mr. Bernasconi will go first, and then followed by Professor Budiono, and then Pak Amri, and then Pak Bayu. Maybe a note to the operator that I will introduce each panelist and the short CV before each presentation, so not all directly at the beginning. So first of all, if I may, I will introduce Pak Christoph's short biography. Yes. It's quite long. It's a very accomplished career, but Dr. Christoph Bernasconi is the Secretary General of HCCH since 2013. He holds a law degree from Freiburg University in Switzerland, an LLM in comparative law from McGill University in Canada, concentrating on international commercial law, a master's thesis in oligopolies in unfair competition law, and a doctoral degree in private international law from Freiburg University. Dr. Bernasconi has been actively involved in numerous normative projects and non-normative activities of the HCCH. And he also designed and administers the electronic apostille program. And in his tenure as Secretary General, he is focusing on the good governance and strategic development of the HCCH, spearheading efforts towards its universality and inclusiveness. And I imagine universality also relates to the adoption and application of various HCCH instruments, including for Indonesia. And I think we look forward to hear what you have to say about that, Bernasconi. So I believe that you have prepared a material on this. May I ask the operator to show the materials for Dr. Bernasconi? Would you like to sit or stand in the lectern? They can, or, that's a good point. Wait, let me, yeah. That's a thing, yeah. Oh, maybe Pak Amri, Prof. Budiono, we're wondering whether you will be able to clearly see the TV. So if it, all right, because because otherwise it may also be okay if you want to sit there first, and then we can sit in front during Q&A.
Thank you very much, Mr. Moderator, Mr. Director General, Mr. Dean, professors, dear members of the associations, dear students, our future of private international law. A heartfelt good morning to all of you, and I would like to express first of all how grateful I am to the University of Parahyangan Catholic University for inviting me, for being here today with all of you to discuss what I hopefully will be the upcoming further integration of Indonesia into the big family of the HCCH, the Hague Conference on Private International Law. What I would like to do according to the program, roughly 30 minutes, but just give me a signal when you think I've spoken enough, because once I get started with these things, it's difficult to stop me, but I will of course be under your guidance. But I would first just briefly present the organization as such, sure that all of us, we are on the same page. I will then talk a little bit about the benefits for Indonesia to become a member and join conventions. And then at the very end of the presentation, I do take the liberty and I add immediately the caveat that this is just a personal view from us at the Permanent Bureau, but I do take the liberty of proposing a roadmap, a possible roadmap for Indonesia's further integration into the HCCH and what could be done in that respect. So without further ado, let's just briefly summarize where we stand as the organization. Of course, is an intergovernmental organization with origins going back to 1893. So for those of you who are familiar with the institutions in The Hague, the HCCH is actually the oldest of all the many legal institutions in The Hague. We're also the only one with a legislative mandate. We are the only organization producing legal norms in response to our mandate, which is the progressive unification of the rules of private international law at the global level. And we do that by developing treaties. We call them the HCCH conventions and other instruments to which states and the European Union can then become a party. And what also characterizes the work of the organization is that we think it's one thing to put these conventions on the table. It's another thing to make sure that they actually work in practice. And most of our resources go actually into these post-convention activities to make sure that the conventions operate properly. And what I like to stress and say also with quite some pride is that the work of the HCCH really stands for effective multilateralism in that it reflects multilateralism that people and companies can relate to because they realize that it makes a difference in their lives or the way that they conduct their transnational business. The image I like to use to describe the work of the HCCH is that of a bridge. We are indeed building bridges in providing these unified rules of private international law, which give this legal certainty and predictability and strengthen cooperation between states. But as I like to say, at both ends of the bridge, the substantive domestic law of the states remains largely untouched. And that's the beauty of private international law, because we unify the private national law rules, we create these bridges, but it stands for the respect of the cultural, political, religious expressions of the domestic law at, again, each end of the bridge. I think the work of the HCCH is important, certainly, yes, and is designed to be effective at the global level, but it is also important at the regional level. And I say this, of course, also against the background of ASEAN, because states like Indonesia can benefit from the work of the HCCH within a regional grouping if all, say, ASEAN states were to become a party to one of our conventions. Well, that would immediately create a lot of integration and cooperation at the regional level as well, which then can also be used at the global level at the same time. And so the HCCH really stands for practical, effective multilateralism. We have, to this day, concluded roughly 40 instruments. I always like to say you can forget about half of them, and you really can, because some of these instruments, let's be frank, have not been successful. Others have been replaced by more modern, newer instruments, but there is 12 to 15 conventions and instruments that I identify as core conventions, the real practically important stuff of the HCCH that I like to focus on. It is called the Hague Conference on Private National Law. We keep using this acronym HCCH. You may wonder why. Well, it's because we have currently still two official languages, English and French. English, Hague Conference on Private National Law. French, La Conférence de l'aide au droit national privé. So if you take the main letters, HCCH, you get the acronym, which is also the URL of our website. Our governing body this year decided to, and I'm very pleased about this because we worked hard for that, our council decided to introduce Spanish as a third official language. And La Conferencia de la Haya then also works with this acronym, so we can stick to that. This slide here reflects the membership of the organization. And you can see that we currently have 91 members, that's 90 states plus the European Union. I never feel comfortable to say that we are a global organization based on this slide, because there is too much gray in Africa, and there is too much gray also in Southeast Asia. But in the Asia Pacific region in total, we have 21 members. That's maybe the figure also to retain from this slide. On this next slide, however, you see that we have a total of 156 what we call connected parties. And that means that there are 65 other contracting parties or states or other contracting parties that, without being a member of the organization, are party to at least one of our conventions. And we have another 21 of these states in Asia Pacific. So there are 42 Asia Pacific states that are connected one way or another to the work of the HCCH, either by being a member or by being party to at least one convention. But it also means that there is more than 30 other states in Asia Pacific that are not yet connected to the work. And so there is still a lot to do. And I'm very getting emotional also to be here in Bandung. You know, the 1955 conference, stressing the importance of Asian African states and their role in the world community. And this is a bit of a reflection of this as well, and an invitation for us to also give a real effect to this Bandung spirit, which has had a big effect on me as well. This slide here shows the percentage of states in regions that are members of the organization. And you see that, for example, in Europe, 91% of all the states are members of the organization. At the other extreme, we have Africa with only 15%, 8 states of Africa out of the 54 are members of the organization. Then you have about half of the states in the Americas. In Asia Pacific, 34% of the states are members of the organization. If you now look at these non-member connected parties, you see that in Europe only 9%. Well, because all of them are, or most of them are members. So that figure is naturally very small. But then again, in Asia Pacific, with 21 other non-member connected parties, it again means that we have 34% of these states that are non-member connected parties. This slide shows the evolution of the membership within the organization. And you see that this has been a steady increase, an impressive increase, in particular since the year 2000, roughly. And we keep adding members, and I'm very pleased with this development. Now, when it comes to Indonesia and the HCCH, Indonesia is not a member of the HCCH, not yet, I dare to add. But Indonesia is, of course, party to one convention, the Apostille Convention, which entered into force in 2022. Now, it's interesting to note that we had quite an impressive increase of the membership in Asia Pacific as well. In fact, since the year 2000, 15 new members joined from the Asia Pacific region. And that is maybe also an incentive for Indonesia to follow suit and join the other states in the regions that have done so. And so most recently from Asia Pacific, we had Kazakhstan in 2017, Uzbekistan 2020, Mongolia 2021, and Thailand in 2021 as well, that became members of the organization from this part of the region. Now, our conventions can basically be structured into three different categories or divisions: international family law and child protection law, transnational litigation and the Apostille Convention, as well as international commercial, digital, and finance law. I will, of course, not be able to go into any details for all these conventions, but in the international family law and child protection law division, we have the child abduction, adoption, child protection, protection of adults, child support, and the maintenance protocol that goes with the child support. These are basically all conventions that enable a state to give real practical effect to the UN Convention on the Rights of the Child. Practically all states of this world are party to the UN Convention, and that of course is a good thing, because the UN Convention on the Rights of the Child is a very important convention. But it is only a framework convention. It is only a convention that says what states should do in relation to the protection of children. But it doesn't give mechanisms to states as to how to protect their children. And this is where all these conventions come in, because these conventions do enable states to give real practical effect to the fundamental principles that are established in the UN Convention of the Rights of the Child. In the transnational litigation field and the Apostille Convention, we have, of course, the Apostille Convention, which applies now to Indonesia as well, which, of course, greatly facilitates the authentication of public documents, and now can be done also in form of electronic apostilles and electronic registers. And I'm very pleased to see that Indonesia already has the electronic apostille in operation as well. That is a really impressive, quick, important development. And tomorrow I will be talking back in Jakarta on the actual implementation and operation of the Apostille Convention in Indonesia. Service, evidence, and access to justice conventions are kind of a tripartite package of three conventions that facilitate the transmission for requests of service of documents abroad. Same for the transmission of requests for the taking of evidence abroad, or to guarantee that there is no discrimination in regard to access to justice when it comes to nationality or the residence of people. Choice of court convention gives a real effect to choice of court agreements in commercial contracts, based on the idea that choice of court agreements are exclusive choice of court agreements. And it basically means that the chosen court, the court chosen by the parties in their contract, has to hear the case. No other court is entitled to hear the case, and the judgment from the chosen court is to be recognized and enforced abroad. This gives real predictability and legal certainty to the commercial operators in their cross-border business, and is therefore an important convention that has quite a bit of momentum. The Judgments Convention of 2019, I like to refer to as a game changer, because for the first time, the world community gave itself in The Hague, based on consensus, an instrument that now facilitates the circulation of judgments in civil or commercial matters. So what has been the case for arbitral awards for decades under the New York Convention will in future also be the case for judicial decisions, judgments, and that I think is a significant development. All these conventions in this category are setting international standards that are recognized as such by institutions like the World Bank, for example, which you may know that the World Bank is working on a new form of the Doing Business report. And in their new Doing Business, whatever they're going to call it, I don't know, they will take into account the Choice of Core Convention and the Judgments Convention. So that will basically say it is easier to do business in these states because they have the Choice of Core Convention and the Judgments Convention in place. The same has been said about the Apostille Convention. The economic impact of or benefit of the Apostille Convention has been estimated to be over €500 million every year for the contracting parties. So that's a huge economic impact and benefit. Finally, in the international commercial, digital, and financial law field, we have the trust, securities, and the choice of law principles, our only soft law instrument so far, which provides like a blueprint to states against which they can assess the effectiveness of their current rules in private international law. And that gives me maybe also, I should have done so earlier, but I would like to say how pleased and impressed I am by the work that's being done in Indonesia on developing a private international law code. We have done that in Switzerland a few decades ago. I know how hard work, or how much hard work this entails. I also know how important this work is, so I can only congratulate all of you who have contributed to this development, which reflects the importance that Indonesia attaches to private international law. And I think that's hugely important because we do live in a world of private international law, a world in which almost everything we do very quickly has a connotation to other legal systems, and thus raises questions of jurisdiction, applicable law, recognition and enforcement, and so on and so forth. And our choice of law principles is maybe something that you can take directly into account in finalizing your code on private national law when it comes to your rules on the freedom you want to give to the parties to commercial contracts to choose the applicable law, because this is exactly what these principles do. And of course, the other Hague Conventions would be a supplement to your PIL codification. All of these conventions, you see, continue to attract contracting parties. You see that the Apostille Convention has always been practically the convention with the highest number of contracting parties, and I let you go through this list, but I'm pleased to see that all these graphs basically point into one direction, which is upwards, which means that states continue to join these conventions, and that's good. Now, what I like to say also about all these conventions is that they are a reflection, again, of the effective multilateralism of the HCCH, because in total, as we speak to this day, we have 1,003 ratifications, accessions, or instances in which a convention is or is about to be brought into effect in a state. 1,003 times, has one of our conventions become a reality in a state. That in and for itself, I think, is an impressive figure. But I think it's even more impressive when you ask yourself, how many bilateral agreements would it take to establish the same network of treaty relations between states? So instead of going the multilateral approach through the HCCH conventions, try to do the same thing on a purely bilateral approach, you would need more than 31,000 of these bilateral agreements. And it shows, therefore, how effective multilateralism can be, in particular when states sign up to these conventions, and how much resources states can save, both financially and in human resources, when they join these conventions instead of going through the hardest work of concluding bilateral agreements. Now, when we ask ourselves, where do these 1,003 ratifications or accessions come from? Okay, the majority comes from Europe, 651, 141 from the Americas. There are 75 coming from Africa, and the rest, if you are quick in math, it's 136 from Asia Pacific. including the one from Indonesia for the Apostille Convention. So that also shows that there is still, room, important room, and it's part of our strategic development really to, rebalance these things a little bit and make sure that really all states of the world benefit from this work of the HCCH and join these conventions. When we now look at ASEAN and the HCCH in particular, we see that out of the 10 ASEAN members, 5 are already members of the HCCH: Malaysia, the Philippines, Singapore, Thailand, and Vietnam. Indonesia is in the same group as Brunei and Cambodia in the sense that these are non-HCCH members, but party to at least one convention. And there is only Laos and Myanmar that are not connected at all currently to the work of the HCCH. This is the fuller picture of the status of our conventions in ASEAN states. And you see that the Apostille Convention and the Child Abduction Convention are the most popular convention among ASEAN states. You also see that the Philippines is the champion currently on the ASEAN states. They have 5 conventions on the record already, and they are actively working towards the 6th one, the Evidence Convention, which will hopefully come soon as well. But again, room for further developments there across ASEAN. Now, when we ask ourselves, how can we best describe in general the benefits for Indonesia to join the organization as a member and join conventions as contracting parties, what are these arguments? Well, when it comes to membership, I think it's important to stress first and foremost that it is the members and only the members that determine the work program of the organization. Only members decide what the next conventions should be worked on. And it is only the members that take an active part in the actual negotiations of the conventions. So if you want to be part of the group that shapes consensus, global consensus on these conventions, you have to be a member of the organization. We do invite a few in the negotiations, but the position of these observer states is not taken into account towards the consensus that's being built. So if you want to have your voice heard, if you want to make sure that your interests are being preserved, if you want to make sure that your issues that you may have with a topic are being effectively addressed, you have to be a member of the organization. Only in that way can you make sure that your national interests are being taken into account in these negotiations. Otherwise, you just take over what has been negotiated by others. That's a significant advantage, of course, of being a member. But it's actually a win-win situation because members, therefore, also bring their expertise to the negotiations. And there is expertise in Indonesia on private international law through the association and otherwise. So bring these expertise to the table and enrich the diversity of the perspectives that we are dealing with in The Hague. This is part of global consensus. This is part of bringing the Bandung spirit to The Hague also in these negotiations. Strengthening the voice of Asia within the HCCH. If you are a member, of course, you can also make sure that regional interests or ASEAN interests are being taken into account. And you benefit from priority access to technical assistance. Only members get this access to technical assistance because we get so many requests for technical assistance that we have to prioritize them. And it's really the members that get them first. And it's, I think, an excellent cost-benefit ratio in the sense that for Indonesia, membership would cost somewhere, it's around 36 36,500 euro. 36,500 euro to be a member of the organization. What is not on this slide, what I should have added, and what I only realized recently, is that Indonesia is the only G20 state that is not yet a member of the HCCH. I think that is worthwhile changing, in particular also after your successful G20 presidency that you just completed. And I think membership in the HCCH will also help and support your request to become a member of the OECD, because practically all current OECD members are members of the HCCH, or states like Brazil and the others that are on the last stages of becoming a member of the OECD, they are already a member of the HCCH, have been for a long time. The only one that's not fully a member yet is Colombia, but they have gone through the process, the voting process already, and would just need to deposit their instrument of acceptance of the statute to become a member of the organization. So these are the main arguments to become a member of the organization. When we now look at the conventions, well, I think I've alluded to all of that already. These are practical solutions that have proven to be effective in our conventions. They are there for you to take benefit from and to make use of them, so that your people, your commercial operators can benefit from the legal certainty and predictability, and from enhanced legal cooperation between states to overcome the often practical challenges in judicial or administrative proceedings. Little impact on domestic legal system, saving resources, improving cooperation and integration. No need to reinvent the wheel all the time. The solutions are there, make use of them. Again, international standards, I mentioned that. Facilitating the flow of people, goods, and capital through these conventions. And protecting children internationally effectively, and participating in rule-based multilateral trade and commerce. And all of that, of course, also has a direct connection with the UN SDGs, in particular goal 16. These conventions are a very effective way of giving a real meaning to SDG 16. In practice, very briefly, becoming a member is basically a three-step process. I would invite, typically it's the Minister of Foreign Affairs or the Prime Minister, to send a letter to the Dutch Minister of Foreign Affairs requesting to become a member of the organization. It is then the Minister of Foreign Affairs of the Netherlands who sends a letter to the Secretary General of the HCCH proposing, say, Indonesia as a member of the organization. I then, on the same date, would immediately open a 6-month voting period, inviting all current members to vote. This is a written voting procedure. It's based on a simple majority of the votes cast. It's a pure formality. I've never seen a negative vote in the 26 years that I have been with the HCCH. So it's really just a pure formality. And once this 6-month period is over and there is a simple majority in favor of admission of a state, the state is then invited to deposit an instrument of acceptance of the statute. And on that day, and only on that day, the state becomes a member of the organization. And the only obligation you have is, other than to contribute to the budget, is to designate a national organ. So that is an office within the government with whom we can exchange all the official communication. The depository of the statute and of all the conventions of the HCCH is the Dutch Ministry of Foreign Affairs. Joining conventions, of course, you have to go through the domestic internal process, which depends on your constitutional framework. It's interesting to note that, but that's maybe something that still needs to be checked. I'm not an expert to talk about this, but the Parliament may or may not have to be involved in the process. If not, then that would, of course, facilitate the procedure. But then at the international level, it depends a little bit on the convention, but it's either a signature and a ratification or an accession. Like Indonesia could only accede to the Apostille Convention, but it could, for example, sign and ratify the Choice of Court Convention. And really, you have to look into every single convention individually. Not that it makes a big difference. It certainly doesn't make a difference in the actual operation of the convention, but it's just something to keep in mind when you join the convention. And you have to designate where relevant central authority or a competent authority, depending on the convention. Now, just in the last 5 minutes, this is, again, a proposal that comes with the immediate caveat that it is only from the Permanent Bureau, so you can shoot at it as you wish. But it may facilitate discussions on how to proceed from here. My proposal is that the first step for further integration should be about the service and the evidence conventions, together with a request to become member of the organization. These, in my view, are what I call the lowest hanging fruits. It is not very difficult to implement the service and the evidence conventions because you already have an office somewhere within your government that receives letter of requests for service and taking of evidence. You basically just have to designate this office as the central authority under these 2 conventions, and you're basically operational. And these conventions greatly accelerate the time, or it shortens the time it takes to get this done out of your way, and the documents served abroad or the evidence taken abroad. We have statistics on how effective these conventions are, and membership for all the reasons that I have already mentioned. Step 1. Step 2 could be joining the Child Abduction Convention. And I'm proposing this based on my understanding, and please correct me if I'm wrong, but my understanding is that a lot of work has already been done on this convention. And it's one of the most visible conventions of the HCCH. It's a really, really important convention with more than 100 contracting parties. So that could be the next step. And I will be very honest and frank with you to say that this would be a huge step forward for us as an organization also to have Indonesia on board, because to have the state with the largest Muslim community a part to the Abduction Convention would send a real signal throughout other Muslim states that this convention works perfectly, as a number of Muslim law experts have confirmed already, that this convention is perfectly compatible with Sharia principles and can operate very well in a Muslim context. Then choice of court and judgments, together maybe with the choice of law principles, if that hasn't been done already. But the choice of court and the judgments convention, of course, are important, as I stressed already, for cross-border trade and commerce, facilitating, supporting cross-border trade and commerce, and also for the ASEAN economic integration. If all ASEAN states are party to these conventions, well, imagine how easy the circulation of judgments would be within ASEAN, and how easy it would be to give real effect to choice of court agreements within ASEAN states. Again, no need to reinvent the wheel. It's there. You can just grab the fruit and use it. Then the Child Support Convention. So that's about the effective recovery of maintenance obligations abroad, because that is a family law convention with significant practical and economic benefits. We are talking about dozens of millions of dollars or euros or whatever that are being recovered effectively through this convention every single year, which is money that the state doesn't have to spend through social services. typically the mothers left behind that don't get the alimony that they are supposed to get. And finally, with a very low priority as far as I'm concerned, the child protection and the adoption conventions. Not that these are not important conventions, don't get me wrong, they are very important conventions also, but the Child Protection Convention is quite a piece. It's a very comprehensive convention. It would use quite a bit of your resources to first with the others and then focus on child protection once you have the experience also with the other conventions. And the adoption convention I put in this category also because simply I do not know how many cross-border inter-country adoptions you have going out of Indonesia. And so I don't know how practical a problem this would really address here in Indonesia. So that's my proposal for the roadmap. Happy to discuss this further. I hope it may also help you in your session this afternoon when you are going through the exercise of identifying the most important conventions, but that's my best take. And so in conclusion, in my view, time has come for Indonesia to be fully part of, benefit more broadly from, and also contribute to the important work of the HCCH. And we stand ready to provide you with any further information or assistance you may need, but I very much look forward to welcoming Indonesia into the ever-growing HCCH family. Thank you very much for your attention.
Thank you very much, Dr. Bernasconi. Next, we will hear from Professor Budiono Kusuma Hamijoyo, who will speak HCC development of Indonesian PIL. And I suppose that Professor Budiono will touch upon some of the things that Dr. Bernasconi said, in particular with regards to possible conventions for ratification by Indonesia. To briefly introduce Professor Budiono, he got of course, Professor, very, very typical of Professor Budiono. In that case, I will ask the operator to, oh, yes, there's already the materials on the slide. Professor, the floor is yours.
Thank you, moderator, John Tobing, for giving me the floor. Good morning, ladies and gentlemen. I first would like to greet the Your Excellency Secretary General, Dr. Christoph Bernasconi. Herzlich willkommen in Bandung. Es freut mich, Sie kennenzulernen. Und hoffentlich treffen wir uns wieder. Your Excellency, Director General Jinangku, I should like to apologize to you for one reason. Because I actually have asked the committee that I should speak after the Director General, because he is a high-ranking official in the Republic, while I am simply rakyat. Dr. Bernasconi, rakyat means common people. Mr. Dean, thank you for being here. I should like to extend my honor to my very senior teacher, Dr. Herlin Budiono, There is an old saying by Confucius. If you meet somebody who will be teaching you for one day, treat him or her like you treat your father or mother for the whole time of your life. And finally, I would like to greet my old buddy, Dr. Payuseto Harju Wahono, who gave me a surprising cadeau on a Sunday evening. So when Dr. Bayu calls me, that must be very important, and he has shocked me for a short notice to come here and speak at this forum. I've been given a very long topic for this session, and I make it short. That reads the Indonesia and the Hague Conventions of Private International Law. And he has given me 5 points to talk about, which I have to deal with now. Number one is the significant cases that I have handled as an Indonesian practicing lawyer. Number two, the currently applicable Indonesian legal provisions to cope with cross-border legal transactions involving corporate and commercial matters. Number three, the most challenging issues in settling cross-border legal disputes in Indonesia. Number four, the pros and cons for Indonesia from the standpoint of the Indonesian business practice to ratify private international law conventions like those established already by the HCCH in order to accelerate the development of Indonesian private international law legal instrument. And finally, the possible challenges in integrating specific private international law conventions into the Indonesian legal system if Indonesia accedes to the private international law conventions. But before I go forward, I would like to have a note on the terms of reference, which I have received from the chairman of the Association of Indonesian Scholars and Observers of Private International Law. The name of this organization gives you a headache, so I will shorten it while my presentation in just association. Sorry for that. My note is the terms of reference seems to focus on certain conventions of the HCCH, which are more business related rather than of humanitarian nature, like adoption of child, mixed marriage, and so on. And as a consequence thereof, I wish to deal with the issues set out in the terms of reference as such and in the points assigned to me to talk about. So let me go to the point number one, significant cross-border transactions that I have handled. I have started practicing law in 1986. That is about 37 years ago. And I started my practice as a crocho. Dr. Benasconi, a crocho means actually a foot soldier. And at the beginning, I did menial works like drafting power of attorneys, doing title search, and there is one very important experience in my initial practice, doing service of process in Jakarta, assigned by a foreign client as per the instruction of a foreign court. I have to do it personally. And from that one experience, I've got to know that there are 7 streets named Jalan Pinang in Jakarta. Until I found the real addressee to whom I should deliver the summons as instructed by the foreign court. That is one of my interesting experience. But from the many cases I have handled, I should like to highlight on 4 projects that I have been involved in. Number 1 is a 10-year period of retention and involvement in transfer of technology in various strategic equipment, whereby I represented an Indonesian state-owned enterprise dealing with numerous strategic equipment, 10 years, single-handedly. And then a 10-year cross-border construction contract involving the Indonesian government and a state-owned enterprise. 1 foreign government and some European and East Asian financiers and contractors. In that case, I work with a team of lawyers while representing the Indonesian state company and dealing with the numerous and complicated documents. The third is a 4-year negotiation process for a cross-border procurement contract for major transportation goods and their related services. I single-handedly represented the foreign company, a European company. And the last case which I would like to mention is a 1.5-year negotiation process assisted by 2 lawyers for the acquisition of an Indonesian manufacturing factory by an European entity which I represented. I should like to note that in all the cases, the contracts were subjected to Indonesian law for interpretation and implementation. In some cases, dispute settlement was subjected to Indonesian court or arbitration, while some others were subjected to foreign arbitration. I have made the observation why in various cases, different choices has been made. And I noticed that when a decision to agree on a certain forum is made, then that is decided by the leverage of one party of the other parties. Sensitive issues were those related to provisions on taxation, licensing, and guarantees, where meticulous and time-consuming negotiations were involved because they have had to be reconciled with each other. The reason for such lengthy negotiation processes were in the difference of various legal provisions in the jurisdictions of the various parties governing such issues, and therefore they needed to be reconciled as well. My point number 2, applicable Indonesian legal resources or provisions to cross-border legal transactions involving various civil and commercial issues. I have the luck to witness the successful consequent conclusion and implementation of the contracts where I had been involved in. And I noticed that we had no serious shortcomings with regard to the Indonesian civil nor commercial legal provisions applicable in cross-border legal transactions. Sure, lengthy negotiations were needed when terms of payments were involved, but they are rather financial procedures in comparison with their legal nature that we are handling. My point number 3, the most challenging issues in settling cross-border legal disputes in Indonesia. This is a very popular topic because it deals with issues like jurisdiction, application of foreign substantive law, recognition, and enforcement of foreign judgment. Negotiations were pretty tough with some contractors from East Asia when agreeing on forum of dispute settlement. But compromise were mostly reached by appointing the SIA in Singapore as forum for settlement. In one case, there was a heated debate, and I would like to say controversial. And I ordered my client to hold the passport of his counterpart in order to let him stay in the country and not leave in the country. That was sometime at 2 o'clock in the morning. More sensitive was the point when discussions come up regarding possible execution of foreign courts rulings or arbitrations awards in Indonesia. Apparently, it was already well known that the execution of foreign courts rulings or arbitration awards in Indonesia were and still are rather cumbersome and in various cases even frustrating. In this regard, I may quote the note made of Catherine Kasejan stating in 2014, well, it is 9 years ago, but still relevant today. 1, decision regarding, she made 4 points. 1, decision regarding the validity of an arbitration agreement between the parties, which is rather ridiculous actually, right? Because if the parties made an agreement, that is an agreement. You have to honor it. And provided they don't breach any law of their respective jurisdictions, then that's it. It has to be respected, even by the court. Decision regarding the interim measures or injunctions, as may be required during some arbitral proceedings. And then a court ruling regarding the possible waiver of an arbitral award, which usually state only one clause in one sentence. And that is open for judgment. And finally, a court ruling declaring the execution or certainly the possible non-execution of an arbitral award. In line with the observation of Catherine Kasejan, Indonesian courts must first ensure the enforceability of the contract made by the parties and the enforceability of a foreign arbitration award within Indonesian jurisdiction. Indeed, there lies the big gamble. Point number 4, the pros and cons for Indonesia to ratify private international law conventions to accelerate the development of Indonesian private international law. I should like to state that I am not in position to represent the opinion of the other Indonesian lawyers. Yet I personally deem that Indonesia needs to accede to and ratify many of the private international law conventions, like those established already by the HCCH. Particularly as the HCCH has already 91 members, if I'm not mistaken, and 65 non-members named connected parties, like what is the case in Indonesia. I have made a note from the presentation of Dr. Benasconi, stating something like, if you want to have your opinion heard and be given attention to by the international community, you should join the international organizations. I have noticed that China is taking membership in almost all international organizations and not stopping there. They're even trying to grab the leadership of those organizations in order to determine the process of world politics. I have the following reasons for my position. Despite the war in Ukraine and tensions about Taiwan, cross-border transactions are becoming increasingly intense and dynamic. leaving almost no single country from interdependence for the procurement of their respective needs of goods and services. I can imagine if Director General would be talking on the further details of this topic. Indonesia is a populous country with 275 million people, which is an interesting market. And increasing also in quantity and the quality aspect of this market. And it is rich in strategic natural resources, which is attractive for, and ironically, for the already rich and affluent countries. Nevertheless, Indonesia is in great need to acquire capital and modern technologies for its industrializations, which we cannot afford to ignore or undermine for the sake of coping with the increasing needs of its 275 million people. You can imagine the need to feed every one of those 275 million people every day. In order for them to prosper and have a better life, the flow of goods and services to and from Indonesia vis-a-vis foreign countries cannot avoid to be embedded, finally, in cross-border contracts with parties from various jurisdictions. If an agreement must eventually be reached and be set out in a contract, if the parties are keen to obtain mutual benefits therefrom, even if they are subject to different jurisdictions, it is in that regard that international harmonization of interjurisdictional rules and regulations is to be attained. So I agree very much with the position made by Dr. Bernasconi. Easier cross-border contracting as supported by the Hague Convention would only bring about benefit for Indonesia in its dealings with various parties from various jurisdictions. I have made the observation that there are various international organizations trying to harmonize, unify various legal aspects of interstate connections and so on. You name it, the Vienna Convention, the UN conventions, and so on. But the HCCH is the single international organization dealing with a very specific important aspect of the private international law issues. And that is very important. Final one. Possible challenges in integrating specific private international law conventions into the Indonesian legal system if Indonesia accedes to the conventions. In case Indonesia accedes to and eventually ratify the Hague Conventions or some of the Hague Conventions, lots of adjustments, accommodations, and harmonizations will need to be made in the Indonesian legal system. That is a big job indeed. But that should be perceived, in my opinion, simply as the cost to be shouldered in an international take and give process. There's a difference between the doctrine of take and give and take, depending from which side you view the case. The problem would rest finally with the Indonesian legislative and government institutions as to how fast and prudent they would work on that and cope with the challenges harmoniously. In this case, the association may certainly contribute their expertise to the Indonesian legislative and government institutions to speed up the process. It might be a difficult, a long and winding road, but I wish you good luck for that. Thank you.
Thank you, Professor Budiono. Next, we will also hear responses, also some remarks from Pak Amrih Jinangkung, the Director General of Law and Treaties at the Ministry of Foreign Affairs. To briefly introduce, Pak Amrih graduates from Gajah Mada University, Faculty of Law, and his master's degree from Cornell Law School. Prior to the position of Director General, Pak Amrih had been the second secretary at the Embassy of Indonesia in Washington, D.C., and among other positions, also the Indonesian ambassador to the Holy See. For Pak Amrih, the floor is yours, Pak.
Selamat pagi. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera untuk kita semua. Thank you, Pak John. Thank you also for the nice introduction. Pak Dekan, Pak Leona Nandang Supriyatna, Prof. Budiono, kemudian Prof. Bayu yang kami hormati, izin kami memberikan presentasi. To start with, I would like to apologize for the organizing committee because I would not present as requested. The title I slightly modified because I don't want to talk about the HCCH. We have the right person to talk about it. We have also the practitioner about international private law. So I would discuss about the development of Indonesian international private law in general from the perspective of Ministry of Foreign Affairs. Okay, next slide. So I will try to talk in short and concise. Three themes that I would like to propose. Why Indonesia has to develop its private international law, and then if Indonesia have to develop, how to develop. The third one is the role of the Ministry of Foreign Affairs in this development of private international law. I'm not a scholar. I would rather say I'm practitioner of international law. Not so much about private international law because the Ministry of Foreign Affairs by its nature is a more political ministry. But somehow Ministry of Foreign Affairs also get involved in the private international law. Okay, the first question, why Indonesia has to develop its private international law? I think all of us knows that there is a growing need of private international law in Indonesia. The border wars that we have now, the successful economic development also intensified the transaction, the communications between people from every corner of the world. So the civil and commercial interactions is increasing. Then the consequences, part of it, I think, there will be an increase of transnational legal issues. Prof. Budiono already mentioned several of them. I don't dwell too much about this. I think everybody in this room, the expert of private international law, already knew about it. Now, what about the situations in Indonesia? The next slide. So I think for Indonesian, we knew this already, but maybe for Pak Bernasconi. What is applicable now is the Algemene Bepalingen van Wetgeving. This is which is a Dutch era colonial law, still applicable now in Indonesia. And we have other recent laws, such as the citizenship laws or the marriage laws. But in terms of international private laws, so there is no one codified private international law. And in this regard, as Pak Bernasconi already mentioned, we are in the process of codifying those laws, putting into one laws. It is it's not an easy job, I know, and the Ministry of Law and Human Rights in the process of doing it. Hopefully, we can be succeeded in this process. And then one also other issue that I think there is a kind of vacuum is the procedural law in terms of private international law. And this is the other issue that will be put there in the laws. So the situations required, I think it is must for Indonesia to develop its international private international law. How to develop the Indonesian private international law? Well, there are many ways to do it, and as scholars, I think the scholars here knew about it. But to mention a few, I would say the not easy one would be creative and created its own private international law. This is the most tough job, and I think the easiest one would be just to adopt or to incorporate the existing conventions on private international law, such as the one those that has been developed by the HCCH. And of course, if we have to adopt it or to incorporate it, then as mentioned by Prof. Budiono, still there is not very easy job to do, such as the adjustment, the harmonizations, and so forth and so forth. The next slide. So if we want to adopt the existing private international law, then we could consider the HCCH is the source of conventions that Indonesia could think about it to adopt it. I don't want to dwell much, and this is the expertise of Pak Bernasconi and already been discussed by him previously. Also, the next slides, some example of the HCCH conventions. Pak Bernasconi already mentioned about it. So the third part of my presentations about the Ministry of Foreign Affairs. What is the role of the Ministry of Foreign Affairs? Next slide. Yeah, I give several examples. One of them is in the cases of service document. The Vienna Conventions on Consular Relations is the basis for the Ministry of Foreign Affairs in this context, our embassies abroad to take part or to use. So the Article 5 of the Vienna Conventions states that one of the task that they have to do is transmitting judicial and extrajudicial documents or executing letters rogatory or commissions to take evidence for the court of the sending state in accordance with international agreements and so forth and so forth. So this is one of the basis for the Ministry of Foreign Affairs. In this regard, our embassies take part in the private international law. For this service of document, we have already an established practice. Next slide. There is a memorandum of understanding between Ministry of Foreign Affairs and the Supreme Court. So in the first one is if there is a document to be sent from Indonesian court to foreign court, so the process would be trying to be as simple as possible. From the lower court, and then the document brought to the Supreme Court, and then Supreme Court sent it to Ministry of Foreign Affairs, and then Ministry of Foreign Affairs sent it to our mission abroad, and then our diplomatic missions abroad send it to Ministry of Foreign Affairs or the competent authority of the receiving state. And for the incoming document, usually the government we received the documents from competent authority of the sending state, or from the diplomatic representative here in Jakarta. They send the document to MOFA and then Ministry of Foreign Affairs. The ministry then send it to Supreme Court and then processed by the Supreme Court. This is the practice that have been done, and as you can see through this, Ministry of Foreign Affairs somehow has a role in this issue of service of document. The other slides, next slide. In the past, we also we also take part in the legislation of document, but since the Apostille Convention has been adopted, then document can right away applicable to domestic court and so forth and so forth, and also Indonesian document can be applicable in foreign countries. But there are issues, or there are documents that might not be, or there is an issue that our consular in our embassies in abroad have to provide legislation services, especially when the issuing country is not a contracting party to the convention, or the type of document sent is not eligible for apostille process. So there is still a role that the Ministry of Foreign Affairs take part. The other role of the Ministry of Foreign Affairs is, this is our traditional role of the Ministry of Foreign Affairs, of diplomats, which is negotiations. In the context of, say, for example, in this case, if we want to have a mutual legal assistance in civil and commercial matters, then Ministry of Foreign Affairs will be part of the team to negotiate this treaty. We have right now one between Indonesia and Thailand on agreement on judicial cooperations between Indonesia and Thailand. We are now in the process of negotiations in mutual legal assistance in civil and commercial matters between Indonesia and Singapore. So in the context of negotiations, Ministry of Foreign Affairs is always part of the team. And the other role of the ministry is in the context of the law of treaties. The law number 24 of 2000, Undang-Undang Perjanjian Internasional, or the international treaties, provide specific roles to the Ministry of Foreign Affairs in especially negotiations. And also if we would like to ratify or accede to a specific treaty, I think the role of Ministry of Foreign Affairs is indispensable, because the process has to go through the Ministry of Foreign Affairs. The minister will be the one who send the letter to the president, and the president will issue a permit to, if the process doesn't have to go through the parliament, then the president directly issue the permit for the government to start the discussion on the presidential decree. If not, the president then send the letter to the parliament asking for permission to ratify or accede to a treaty. So this is based on our laws. The minister has a very important role, and at the end of the process, the minister will also provide a letter stating, or the letter that will be sent to the, in this case, the SCCH Secretariat or the Dutch Ministry of Foreign Affairs, that Indonesia is ratifying and thereby bound by a specific treaty. So what I want to say is, this is the role of the MOFA that we have to do if we are going to accede to a treaty. The next one, we have ratified one Apostille Convention. The questions, I think, would be, what next? I think the experts are already here, the associations. Your voice is, I think, very pertinent if we would like to, or if you would like to propose specific conventions to be ratified by the government. There are discussions actually in the government, within the government, of several conventions. Taking off evidence is one of them, and the discussion is still ongoing. The other issue that I think is also important is still discussed and discussed and discussed. This is about the membership of Indonesia to HCCH. I'm aware that the HCCH is doing their best to outreach Indonesia since maybe early 2000, approaching us to be member. But again, the discussion is, I think now has not been conclusive. So again, your voice of the association is very important. If you, because there is a balance right now for those who against and for those who support. So we need something to break the balance. So if you could voice your support for membership, for example, or you against the Indonesian membership, for example, just say it loudly, so that everybody can hear it. And then this is a democratic country, so your voice matters. This is the way you could influence the government's policy decision-making process. I think that's all. Very short. I'm sorry. I would prefer to talk more about the Ministry of Foreign Affairs, something that I would know best. Thank you very much, and have a fruitful discussion. Thank you.
Thank you, Pak Amri. And finally, we will have Pak Bayu Seto Harjowahono, who is also the president of the Association of Indonesian Lecturers and Observers for Private International Law. I think most people in this room will already be very familiar with Pak Bayu, both well, both as a person as well as his academic credentials. And specifically for that reason, we are looking forward to hear from you on legal analysis on some of the HCCH instruments that you think will be very important.
Thank you, John. Your Excellencies, Professor Bernasconi, Pak Jinangkung, Prof. Budiono, I feel lucky because I was given the time, as a last speaker, because I can, pretend to conclude, all the materials that have been given by the previous speakers. But it is.
Please conclude in 20 minutes.
Sorry?
Please conclude in 20 minutes.
20 minutes. Okay, I'll try my best. Where was I? Okay. Without any negotiations before, I come to the idea of filling the theme that asked by the committee to talk about the potential role of the HCCH conventions to complement the future Indonesian private international law. It's some kind of an academic discussion among us within the association. So let me start with this. Let's say our language, our terms. This private international law, as we understood generally, is, let's say, the branch of national law dealing with legal issues in civil and commercial matters, mostly containing foreign elements. This is a theoretical definition. We all know about that. In Indonesia, private international law is considered as a sub-branch of the general conflict of laws, the hukum perselisihan. This general conflict of laws, or in University of Indonesia, it is known as external conflict of laws, vis-a-vis internal conflict of laws. Well, okay, let's not go further on that. And scope of the private international law is usually include 3 points, three matters: choice of jurisdictions issues, choice of the applicable law, or choice the applicable substantive law issues, and the third is the recognition and enforcement of foreign judgment. But currently, we also add one more important thing, and this is where HCCH become very relevant. It's about the international harmonization and unification of private international law matters. And this become one of the important issues that should be included in the private international law as a theoretical legal branch. So let's see what is the existing private international law in Indonesia. I seems to conclude what Jinangkung has spoken before. So start with some disappointment. Why? Because private international law is one of the least developed branches of law within the Indonesian legal system. Within many Indonesian law school curricula, private international law is usually acknowledged as a theoretical legal subject with less practical significance. And that we have to admit that that is what going on in our law faculties. Academic and political efforts to change this attitude since the mid-20th century towards the establishment of a comprehensive private international law system in Indonesia seems rather unsuccessful. There are so many drafts that has been made by the let's say the famous Professor Sudargo Gautama, by the BPHN, by the National Body on Legal Development, but it's all comes to nothing. So until the, let's say that first years of the 21st century, it is still a static, no development, no significant development. But to this day, and this is what Pak Jinangkung has mentioned before, to this day, why it is the colonial, because three main traditional private international rules that applied by courts in Indonesia are those enforced since the colonial times. The Article 16, Article 17, and Article 18 of the Algemene Bepalingen van Wetgeving, or maybe translated into General Provisions for Legislations for Indonesia, enacted in 1847. So we are still holding on these three main private international law rules or principles until today. So let's see how modern we are now. So Article 16 deals with matters regarding personal status and family matters. And the one and only principle that's used is the Lex Patriae, or law of the nationality principle, Lex Patriae, the law of the nationality of a person. Article 17 deals with immovables, benda tetap. Regarding immovable property, we use one and only principle, the Lex Re Sittae, or Lex Situs, place of the where the goods are situated. And then the Article 18 deals with regarding juridical acts, and we use the single principle of Lex Loci Actus. So this is the Indonesian courts hold with only these three principles when dealing with private international issues. So this is very disappointing until promising development occur in 2019-2020. The Ministry of Law and Human Rights, strongly supported by the Ministry of Foreign Affairs, the Supreme Court, and the Private International Scholars Association, also known as the Association, finally agreed to put the National Private International Law within the National Legislation Program, PROLEGNAS. And that is a good, really good news, because we are achieving something concrete with the effort to harmonize, to develop our private international law system. And projected for enactment in 2024. Correct me if I'm wrong, Budina. Yeah, projected for enactment in 2024. And this is an opportunity that I would like to use to, let's say, give a big picture about this draft. It is a bill draft of a partial codification of private international law principles and rules. And the current draft in 2022 contain of 10 chapters and 70 articles. So it is a comprehensive codification, but still we should call it a partial codification because there are some private international law matters were not put in the bill draft until today. And what does this law cover? It covers general private international principles and rules. And I'm glad that while designing this, the team always check out the main principles that we can find in HCCH conventions. So I think we are developing in line with what the international trend should be. And then we have the rules on international jurisdiction of Indonesian courts. We have rules on the applicable law for civil and commercial matters. So this is the first issue of private international law. Oh, it doesn't work. It works here. Okay. Just rules on international jurisdiction, rules of the applicable law for civil and commercial matters that include personal status, family matters, property matters, contractual and non-contractual obligation, and succession or inheritance law. So this bill draft is covering these issues. Private international law principles and rules on these issues for the deciding the applicable substantive law for civil and commercial matters. And then also the rules on recognition and enforcement of foreign judgment. So this is practically a complete codification of private international law issues, although not as complete as the Swiss Code of Private International Law, but as a start, we should be proud of it. And this is the one important thing mentioned by Pak Jinangku. This law will also provide a portal rule for international legal cooperation for designing bilateral or mutual legal assistances between states and for dealing with international organization. So there is a, let's say, a portal rule that allows the government, allows the Supreme Court, or allows the Parliament to establish international relations through cooperation in private international law matters. So this is the good news. And other highlight that should be mentioned, this law will, well, hopefully, will circumvent the use of hard and fast private international law rules like the Article 16, 17, or 18 of the Algemene Bepalingen. And the draft resort to the use of alternative and more flexible principles and rules in line with the international trend and the best practices. And for this approach, we also learn much of rules and principles used in HCCH conventions. How we use more flexible and more variative principle and rules. For example, that shows the flexibility. Examples, we introduced the use of law of habitual residence as an alternative to the law of nationality. We use the lex loci damni as an alternative to the lex loci delicti principles. Choice of law in contract, it is almost free. Freedom to choose the governing law in contract is only limited only by the public order, the mandatory rules of Indonesia. And then best interest of children, that become one of the main principle within the part of child adoption, child protection, and family law. This best interest of children becomes one of the highlighted new principles. And then the real and substantial connection principle as an alternative in many cases where nationality principle or habitual residence doesn't work well. And then we adopt this law adopt the real and substantial connection principles in many instances. So, important entry points for international harmonization of unification of private international law. First, there's a leeway for Indonesian court in specific situation to comply with international well-observed principles and usages. This new law, when it is enforced, will open a leeway for Indonesian court for specific situation to comply with international well-observed principles or usages. So even if we don't accede to ACCH, but their conventions contains well-observed legal principles in private international law, and this law made that possible for Indonesian court to adopt those principles in certain situations where the hard and fast rules doesn't work in certain cases. And then this is you can find this in Article 4 of the draft. And then freedom to choose the applicable law in contract is mainly limited by public order, mandatory rules, and morality. This is also in Article 50 of the draft. And then widely recognized international usages may be applied by the court to establish a valid contractual choice of law. This is a new one for Indonesian system, and we learn much from the new principles of choice of law and from the ACCH soft law principles. And this is regulated, provided in Article 56 of the draft. Another thing, a recognition of parties' contractual choice of forum. This is something new within our private international law system, but learning from the ACCH Convention on Choice of Forum, we also put the possibility for the Indonesian court to claim or to deny jurisdiction. The freedom of the parties to choose the forum. And until today, there is always some misconception about choice of forum and choice of law in many courts in Indonesia. But by defining the difference between choice of law and choice of forum, I hope that in the future, private international law cases will be solved in a more truthful manner. Article 69 and 60 of the private bill. And then lastly, Indonesian court may supersede, and this is an important entry point to accede to ACCH, for example, because the Indonesian court may supersede the private international law when international law treaties binding the Republic of Indonesia as a contracting state establish rules that differ from those in this law. So the court has the authority to how do you say, to establish rules that connect to international conventions where Indonesia is contracting state and supersede this private international law. So this is another new approach, I think, that will be important if Indonesia will accede to many conventions as such from the ACCH or the UNIDROIT and some other organization. So this is set in Article 62 of the Private International Bill. So those open provisions were considered necessary to reveal an outward-looking or open attitude by Indonesian future private international law system towards international harmonization and unification. So it's more outward-looking. And important role of international organization to encourage and to support Indonesian active participation in such harmonization and unification process. With this new law, which open with this outward looking, outbound looking, is important so that international organizations will be involved in and encourage the development of Indonesian future private international law system. And at this point, HCCH has one of the leading organization in global private international law development, could play a pivotal role. This is what I believe. So I'm nearing the end. Indonesia, sorry to say, is not yet a member state. Indonesia ratified only one convention, the 1961 Apostille Convention. But meanwhile, intensive discussions and debates within the ministries, judges, and academicians are ongoing on the importance and possible accession of the 65 Surface Convention, the Child Abduction Convention of 1980, and of course, the Evidence Convention. This was intensively discussed within the Ministry of Foreign Affairs. We participate in so intense discussion on especially the Surface and the Evidence Convention. But there are pros and cons about how about our national sovereignty and whatever. But in general, this is the three most important convention that need to be ratified or accessed by Indonesia. Among scholars, on the other hand, within the private international academic circle of research, the choice of court convention becomes more and more popular. The 2005 choice of court convention, the 1965 Surface Convention, sorry, it should be, this is a mistype. Well, okay, just trust me. The 2015 Principles on Choice of Law in International Commercial Contract. This is a soft law, but it contains very important principles on choice of law, and the most late the 2018 Judgment Convention. These becomes more popular. I will correct this 1965 on Surface, but this is most popular among the scholars to discuss about the importance for Indonesia to ratify this convention. I think it should be on the choice of forum, choice of court convention. Well, I cannot remember. Well, okay. But these are the situation. These are the situation in Indonesia right now concerning HCCH. It is one of the most important international organization that influence private international law development. Its provisions, its rules and principles known put in various conventions is also adopted in the new private international law bill draft. So this is how the HCCH conventions influence our development, even if we are not yet becomes a member of the HCCH. Not to say that so whether we become a member or not a member is not important. No, that is not the point. The point is, this is a proof that the product of the HCCH in their convention contains really an international well-observed and well-accepted principles. And that is what we try to adopt within our new coming and the future private international law in 2024, hopefully. So finally, necessity for Indonesia to become member state of the HCCH become an important issue. Why? Also to actively participate in HCCH future projects that I read in the in HCCH website, aimed at establishing global private international framework. For example, in Indonesia, it is relevant to participate, of course, as a member country, in the project on intellectual property, and then on international tourism, because tourism in Indonesia become more and more a big industry, with foreigners coming to Indonesia with many intercultural problems and so forth. So Indonesia participation in international in future project on international tourism will be very important. And then finally on jurisdiction, of course, because there are a follow-up project on jurisdiction, as I understand, in the HCCH, and I would say that that's one of the future projects that Indonesia should take part. And as a member of HCCH, we can only take part in participate in such a future project. And many other projects, but this is the highlighted most important thing for Indonesia, I guess: intellectual property, international tourism, and jurisdiction. Okay, so what should we do? Hopefully, this conference lead to the conviction that Indonesia's active membership in the HCCH is necessary and important. The Indonesian Private International Law Association need to formulate a set of argumentative recommendations to the government, as requested by Pak Jinangkung, on these matters, on what is the pros and cons, what is the benefit of become an HCCH member. Although we all know the trend is, well, there is no cons in that, because there are so many benefits that we can receive in developing our private international law in the future. Well, that's all that I can give you. Thank you so much. Assalamualaikum warahmatullahi wabarakatuh.
Thank you very much, Pak Bayu. And at this point, thank you to all of the panelists for a comprehensive overview from the HCCH, and then the response from the practical side, from the government, and the academic side. Thankfully, we still have a lot of time for Q&A and discussion until 12 noon, and we'll open the questions. But before that, if I may, perhaps two sort of gateway questions, especially in the context of HCCH conventions or instruments being ratified or adopted by Indonesia So two specific questions. First of all, to Pak Bayu, you said that in the draft PIL Act, most of the provisions are already drafted or prepared in such a way as to conform with international instruments, including HCCH conventions. But if I may, this can also lead to or give rise to a question as to concerning these matters that have been covered in both the PIL Act and the HCCH instruments. What then is the necessity or the urgency to adopt or to ratify HCCH or international instruments if the principles in the PIL Act have been aligned? It may be obvious to some of us, but I think it will be helpful if you zero in on that particular point.
Yes. Well, working. To answer your question, well, the drafters of the private international law bill that, as far as I know, there's Ibu Lita here, there's Budina. As far as I know, should function as a portal law. So it is important for Indonesia to decide whether a case containing foreign elements that Indonesia should apply or not. So this is the main function of the Private International Law Act, right? But what kind of principles that we use in designing the Private International Law Act or the new bill, let's say the new draft, is that we look into what is the most mostly used, commonly used in international practice, and one of the source of information is the HCCH conventions. The HCCH conventions on several matters, on family matters, on jurisdiction, but we decide to use this principle, to introduce these principles in the new bill draft, is because these are the well observed, well accepted principles. And we know that for sure because it is adopted in the HCCH conventions. That was it. That was the original intent. So it has nothing to do with whether it is still important, because there are some issues within the within the bill which is not specifically addressed. For example, for how to obtain evidences, how to what the surface of documents. There are no rules on that. With the thing in the back mind is that we can ratify those two conventions. That's the way the committee works, I believe. Thank you.
Of course, Doctor.
Sorry, thank you very much, Mr. Moderator. I didn't mean to interrupt, but thank you also for this clarification, Professor Babayu. I understood the question in particular also to mean if a specific topic is being dealt with in the code and it is in line with an HCCH convention, why then still join the convention? You have it in the code. Why join the convention? Well, I think I can think of two important arguments why you would still wish to join the convention, even if from a substantive point of view, you have key elements in the code already. One is accessibility foreign parties. It is much easier for a foreign party who wants to know what is the status of Indonesian law on this matter to simply check if they are a party to the HCCH convention, as opposed to try to find out by going into national legislation. That's true not just for Indonesia, it's true for any other legislation around the world. Since the HCCH conventions are standards, parties really refer standard apply in a given country, yes or no, and to do so, they simply check our website and whether to see whether or not that state is party to the convention. It's much easier for them to do so. The second thing is the long-term interpretation of these texts. It is crucial for states to be party to these conventions so as to make sure that we all continue to interpret the application of the text of these conventions in a uniform way. If you have your own way of reflecting the substance in your domestic legislation, but you're not part of the original, if I may say so, there is a danger that the interpretation of the rules under the original, under the HCCH conventions, which we monitor very precisely, and we have regular meetings on the practical operation of these conventions, which are also done so as to ensure a uniform interpretation. If you're not part of this movement, there is a danger that nationally your interpretation diverges from what is in the original. And then you have a big problem, because then you say you have, you know, the equivalent of the convention, but in fact you don't, because you don't interpret the terms in the same way. So that's why I would still say it is helpful to see the substance reflected in the code, but to me it's not an argument then to say, well, since we have it, we don't need to join the conventions.
Thank you.
May I add? So that's why in realizing what your thought was, that's why there is an article that I mentioned before, that if Indonesia is bound by a certain convention, international convention, and then Indonesia's commitment can supersede this law. So what is the international practice which regulates, provided in these international conventions, would bind the courts in Indonesia, and it will supersede the law. To avoid that, what you worry about the different interpretation of the general rules in national or political context within a state, and that's why we anticipate that also in the bill.
If I understood correctly, Article 62 only applies if Indonesia is party to the convention.
Yeah.
So
That's why. That's
Precisely the
That's why
reason.
I call it an entry point for Indonesia to become a party.
Now, in terms of the business of Indonesia becoming a party, there are Professor Budiono and Pak Bayu have already pointed out a few issues, a few areas of importance in practice and of academic interests where there are several HCCH instruments that need to be considered for adoption, for ratification. And this in particular, I addressed the question to Pak Amri while you're here, because on the other hand, it's interesting that Dr. Bernasconi also pointed out that it might worth prioritizing, quote, low-hanging fruit. My question is, especially from the perspective of the government, when considering international instruments for ratification, how do you balance these various interests, academic interests, demands from the necessity of practice on the one hand, and then on the other hand, just the practicability and feasibility of actually implementing a convention?
Thank you very much. I think in terms of interest, it's not only between government and academic and business, but also among governments, ministries, they have sometimes different interests. For example, for the Ministry of Foreign Affairs, with the Ministry of Law and Human Rights, they might have different interests, so they might propose the different convention to be ratified first. So the ideal situation would be if we could have a thorough and exhaustive discussion, and then conclusion would be the best conclusion that we can make. One particular issue that that would be important to make a decision, for example, the urgency. How urgent? If we have choices, then and all of those choices, let's say two or three choices, those choices are very important, and we have to do it, all of them. But usually we would prefer to do it one by one, because when you enact or draft a government presidential decree, you need resources, and there are other decrees or issues that also we have to deal with. So we make a selection on the basis, for example, of the urgency, the availability of resources, the export, and so forth and so forth. That's the insight or the matter that we discussed during the governmental discussion.
Oh, sorry, but you.
And then usually we also at the end of the day will be consulting public. So that's why the role of the association is also very important.
I sense that Professor Budiono perhaps had a comment.
I have no comment, but I have a question. If I am allowed to Pak Jinangkung, because we have had a very important and difficult case in our practice. You said before that in case the Ministry of Foreign Affairs deems it important to ratify a certain international treaty, then the Ministry of Foreign Affairs would send a letter to the President requesting for such ratification. Correct me if I'm wrong. And then the President would decide whether the ratification could be made by his own authority or proceeded to the Parliament, if that is correct. My question is, what would be the parameters of the President to decide on whether the process of ratification should be decided by himself or proceeded by the Parliament? Thank you.
Thank you. For the first part, I'm sorry if I'm misunderstood. So at the process of ratifications, it must go through the Ministry of Foreign Affairs. But when we, let's say in the case of the HCCH convention, the one who decide which convention to be ratified or accede is not only the Ministry of Foreign Affairs. So once it is already been decided by the government, which means Foreign Affairs and then Ministry of Law and Human Rights and other ministries, then the Ministry of Foreign Affairs will write a letter to the President. So the ministry is not decided by itself, I want to ratify this and then send letter to president. Because in our system, there must be a ministry that would be the one that we call pemprakarsa, the one who initiate of the process, the pemprakarsa, and then the pemprakarsa will send letter to Ministry of Foreign Affairs based on the decision of the governmental meeting, and then the process going on, letter to the president. Whether it must go through the parliament or can only be decided by the government through the presidential decree. The parameter is in our constitution, but so the constitution mentioned that in Bahasa Indonesia, if a convention, a treaty will have berakibat luas dan mendasar, that will have an impact, wide impact, and a very basic impact, berakibat luas dan mendasar terhadap kehidupan masyarakat, termasuk harus menyebabkan adanya perubahan terhadap peraturan undang-undang, then it must go through the parliament. This parameter has been set by the Constitutional Court. So based on the law of treaty, we have very simple parameter. If the treaty, the conventions is dealing with, for example, national security, sovereignty, and then human rights, environment, and so forth and so forth, it must grow to the parliament. That's on the basis of, there is a six category of treaties or conventions that has go through the parliament based on the Undang-Undang Perjanjian Internasional, the treaty law. And this parameter has been challenged by a certain civil society to the Constitutional Court, and the Constitutional Court said that this, I think Article 9 and 10 or 10 or 11 of the law of treaties, it must not be interpreted only in accordance with that sixth category. It must be a broader scope of category, which is apabila berakibat luas dan mendasar, maka harus ke parlemen. So basically, wide reason it must go to parliament. In the case of the HCCS convention, I think if we take a look at the previous practice, which is the Apostille Convention, it didn't go to the parliament. What about the other convention? I'm not sure. We still have to discuss it. It will be much easier if it doesn't have to go to the parliament. But we have to think whether or not it will have very wide impact to the society, to the country, and also if there is a need to change or to make a new laws, then it must go to the parliament. Thank you.
Thank you.
But I'm very specific on the draft PIL Act, especially the entry point provision that Pak Bayu said, that one of the provisions in the draft PIL Act is the court may sort of create or set aside the provisions of this PIL Act if there is a private international law convention that Indonesia is a party of. Wouldn't that have the effect of making any and all PIL Act subject to parliamentary ratification? Because it has the effect of sort of possibly derogating from the PIL Act.
Well, Good question. But the thing that I can have in my mind is that since the PIL Act would be enacted, would go through the parliament and would be agreed by the parliament, we might be might interpret that, and at the beginning, again, this is my personal views. At the beginning, the parliament has already gave an approval for the HCCH convention to supersede our laws. We can see it from that angle. But again, this is my personal views. Scholars might have different views. Thank you.
Thank you. I'm sorry. I think we have taken enough time already for questions amongst ourselves. Let's open the opportunity for all those here to have questions, perhaps 2 questions at a time. Please state your name and affiliation before posing the questions. Do you need the mic? Yes. Take one. Sure. Yes.
Thank you very much for the opportunity. My name is Kuku Dwi Erlangga from Asaga Famzain Partners. I would like to ask all of the panels in relation to whether or not it is possible to recognize and enforce a foreign judgment in Indonesia, particularly taking into account the tendency of Indonesian courts to somehow be offended by foreign decisions. For example, we have the Astro Ayunda cases where an injunction from the tribunal seated in Singapore, which somehow was considered by the Indonesian court as an interference to their sovereignty in deciding a judgment. Thank you.
Thank you, Mas Kuku. If I may ask you to clarify, do you refer to foreign court judgment or arbitral award? Because Astro case, that was an SIAC.
Yes, I'm asking specifically for judgment, but taking into account their tendency to somehow be.
Yes. All right.
Yes.
Yeah. So that's the first question. Maybe we can take in one more question before the panel answers. Is there anyone else? Or
Thank you. My name is Mutiara Hikmah. I want to ask to Mr. Amri from Foreign Affairs Ministry if we discuss about Bill of PIL of Indonesia. We have it long time ago, since 1983, when our president was Suharto. And now, time gone, we have 6 presidents, and I want to know about the political will of government of Indonesia, because we have two dimensions to a side. The other side from the HCCH to support, to suggest Indonesia as a member of the convention, the Hague Convention. And the other side, what is the importance, the urgent of that two sides? Indonesia has private international law with the regulation that related to Indonesian condition, or as a member of HCCH of convention. That's all my answer. Thank you.
Thank you, Ibu. Maybe the first one about the recognition and enforcement of foreign court judgment, but also taking into account what court practices have been in enforcing foreign arbitral award. Is there anyone who would want to take this on or comment? Maybe, maybe, I don't know, Pak Bayu?
I try my best. Well, at present, we have the Article 436 of the RV, of the RV, Rechtsvordering, which in general, Indonesian courts should deny any request for recognition and enforcement of foreign judgment. And essentially, it means in a specific cases, they might recognize and enforce foreign judgment. If I'm not mistaken, if the cases concerning admiralty case or on ship but in general, the current Indonesian private international law avoid recognizing and enforcing foreign court judgment. But in the new law, in the new draft, let's say, it is formulated a bit different. Basically, the Indonesian court may recognize and enforce a certain type of judgment. But with a certain condition. One of the most important condition is the principle of reciprocality. Reciprocality. It means that if the requesting state is a state which is in binding convention or agreement or international agreement with Indonesia, then we might recognize and enforce their judgment in Indonesia and vice versa. So Indonesian court judgment would also be recognized and enforced in that foreign country, providing that these two countries, Indonesia and the other country, has agreement, international agreement, bilateral agreement or multilateral agreement, which bound the principle of reciprocality in enforcement. If that is the question. Prof. Budi.
Thank you. Well, sorry, I am not familiar with the recent cases involving Indonesian courts executing foreign judgments. But I can recall a beautiful case from a time during the Suharto era. The case was involving the Indonesian government vis-a-vis Kartika regarding some assets deposited in Singapore and brought before the Singapore High Court. The important witness was General Murdani. And he brought up very simple evidence written on a tissue paper. And the case was won by the Indonesian government. And we can imagine that it was easily executed by an Indonesian court. Thank you.
Now there's the political will. Well, the next question is, what would it be when it comes to HCCH or Indonesia becoming a party to the HCCH? Perhaps there is also one follow-up question, if I may, Pak Amri, related to this. Is there any particular consideration of whether being a member of HCCH takes precedence over ratifying HCCH conventions, or will make it at least easier or more palatable to do one way or the other first?
Okay, if I may, I would also first comment. Well, first, I'm not the scholars. The best people to answer, I think, would be those who were in the judicial hakim, whatever. But from our perspective, as a practitioner, as an executive part of the government, we feel the impact of this case from at least from the Ministry of Foreign Affairs side. For example, Pak Penaskoni mentioned about ease of doing business. And if we take a look at the ISDS case, on the arbitral award on the ISDS case, one of them may be on the Karahabodas, where it's not ISDS, but the Karahabodas and also other dispute. Currently on the satellites with Menteri Kementerian Pertahanan, the arbitral judgment. We may, on the court, may not in favor of the execution of this foreign judgment, but they can still enforce the judgment through many ways, such as seizing Indonesian assets abroad. And this is the discussion that we have on. This is something that we, the government, would like to avoid. For example, on the Karahabodas case, we don't want Pertamina assets, say in New York, in London, to be seized because of this judgment. So the issue, I think, has been, becoming, having a bigger attention from certain people, and hopefully this issue can be, at least there must be something to deal with this. I don't know how and what, but let's see, because it will impact also the ease of doing business and so forth and so on. And this is just a comment. On the political will, well, the fact that now the government drafting the bill, I think it shows our political will already. Why now 2020? Why not 1983? I think, as you mentioned, in 1983, the attention, if you don't want to mention it as political will, the attention is already there. But why it didn't happen, I don't know for sure. But the political will, if we talk at this stage now, the political is already there. But the battle, I have to remind you, the battle has not been started yet. I mean, maybe it's already been started, but the real battle is not, because you have to bring it to the parliament, right? And they have a list of RUUs that has to be discussed and has to be decided. And next year is political year, elections, the new parliament, and so on and so on. But let's be optimistic. Let's be optimistic that it will be, that the idea to have it enacted in 2024 could be materialized. That's what God knows. On the membership of the HCCH, this is, as I mentioned in my presentations, we discussing this we discuss it since long time ago, and hopefully there will be a break of the balance with the support of the associations. I don't know how, but let's see. And hopefully, if we become a member of ACCH, then there will be more willingness or more support to accede to more conventions of the ACCH.
Thank you, Professor. If
Kinangkung mentioned the case about Karahabodas, right? I was a little bit involved in the case. And as far as I know, Pertamina lost the case. Yeah. The government wasn't quite willing to pay. But the New York court threatened that if Indonesia doesn't pay, Pertamina assets in the US would be confiscated. That was the end of the story.
Yeah, thank you. They are not only not willing to pay at the beginning. They don't want to go to the arbitrations. They didn't go defend themselves in the arbitration case at the beginning. That's why they lost.
If I may, Mr.
Yes.
Moderator, I have a small comment on this ongoing discussion, and a couple of other things that I would like to share. But in terms of general analysis of the recognition and enforcement of foreign judgments, if you look at the bigger picture, there have been states that traditionally have been quite open to the recognition and enforcement of foreign judgments. Some only on the basis of if there is an existing agreement between the two states, others on reciprocity, others have been quite reluctant to recognize and enforce any foreign judgments in civil or commercial matter. What we observe from the HCCH perspective is that there is clearly a tendency towards more recognition and enforcement of foreign judgments, even in states that were traditionally reluctant to do so. And I can think of states in this region. Thailand is one. China obviously is another one, and I'm sure you have followed these developments. China has started to recognize and enforce foreign judgments much more easily now. So I think this is all a recognition of the fact that the world is moving. And that you can't remain isolated towards the acceptance of foreign judgment, of course, with the relevant safeguards and conditions and all of that. And the Judgments Convention of 2019 does exactly that. It provides the world community with a framework with the relevant safety vaults and safeguards that should facilitate the recognition and enforcement of foreign judgments. On the question on membership, I would first like to add that, yes, of course, we at the HCCH, we would like and love to see Indonesia become a member of the organization, because it would be an expression of our strategic development towards universality and inclusiveness and all of that. But it's not just for the HCCH. It's really even much more for Indonesia. In my view, it would be a much more appropriate reflection of the status of Indonesia in the international world scene now, and in particular also in the upcoming years, with the growing economy, with the growing importance on the geopolitical scene, for you to be a member of the only organization that deals with private national law at the global scene. So if I may, it would be a win-win, and it's not just good for the HCCH. I think it's in particular good for Indonesia to be part of that forum and thinking about the G20 and all of that. So I have a question to DJ Jinangkong, which is, because you were referring to, we are kind of facing a balanced situation. There are some in favor, some against. What are actually the arguments of those who oppose membership? Because it would be helpful to know these arguments for us to address them effectively. If it is financial, I just don't believe it. I'm sorry, because 36,000 euro is a drop in the ocean in the budget of the Indonesian government. So there must be other reasons, and I would just love to know what these reasons are. And while I have the mic, maybe if I can make this call to the association, because DJ Jin Hong Kong has been so kind enough to say that, you know, you have a voice and your voice matters. And that's wonderful to hear from the government representative. So can I encourage you to take the Director General up on his offer, and please do send a letter, a communication, whatever it takes, to the government in support of the conventions that you will be identifying this afternoon, maybe on the basis of the roadmap that I took the liberty to suggest, and you do with it what you want, but maybe it can you know, help your discussions. But please take him up on the offer and express your view. What the DJ hasn't said, and which I think I'm not going to reveal a secret here, but they received a letter just a couple of weeks ago from the Supreme Court in favor of service and evidence. So if they now get another letter from the association that also says we think service and evidence and maybe a few others in that order of priority would be a good thing, and don't forget membership, I think that may actually make the balance tip the other way, and see Indonesia then actually embark on a process of becoming more integrated in the HCCH. Nothing would give me more pleasure than this at the moment. Thank you very much.
But Amri, should we apply the Chatham House rules, or should we ask the association to set up another session just for that? Yes. Oh, yes. Okay, so we have just a little time, and then there's one last question. Zoom, that perhaps the organizer for you, Tiara, can get it for us.
Okay, for the first, there is two questions actually, Pa. For the first question, it's submitted by PWNI D. Erlangga. It is interesting to note on the statement of Professor Budiono about less humanitarian convention produced in HCCH. Within this context, and also to make it even more relevant for Indonesia to consider its possible membership in the future. Could Dr. Bernasconi elaborate more on the dynamic or conversation of the current issues discussed by members of HCCH and share his precious perspective on the tendency or current trends that are priorities of members in convention-making process? And the next question is, what is your opinion for the membership of Indonesia to HCCH cost comparing to the efficiency that will get based on the theory of economic analysis of law? Thank you.
Maybe you can deal with the first
question. First, in relation, thank you, first of all, to those who raised the question. First, in response to Professor Papayu's comment, apparent comment, because I didn't understand it the same way. I don't think you said there is less humanitarian or you know, peoples-related convention at the HCCH. I think you were referring to a situation where apparently there is less discussion on these conventions at government level when it comes to possible conventions to sign and ratify for Indonesia. Because certainly at the HCCH, a very important block of our work does relate to humanitarian, in the broadest sense, you know, human rights issues, let's put it like that. In fact, the whole block of international family and child protection law, of course, has an immensely important dimension of human rights protection of vulnerable people. The same can be said about the protection of adults, which is an increasingly important topic as well. So that's why I included some of these conventions in my roadmap. Again, in the order that I explained, but I wouldn't like to be seen or quoted or whatever to have said that there is less humanitarian related or human rights related work or of less importance. No, it is an immensely important part of our work, and I would even go as far as to say that even the other conventions deal with effective access to justice when it comes to service, evidence, choice of court, judgments. This is all under the general heading of effective access to justice, which in and for itself is also a human right. So lots of that in our work. Looking at current work or future work, we have currently 2 working groups that are active. One is on the question of establishing parenthood in international situations, including those arising out of international surrogacy arrangements. A very delicate, a very sensible topic, one that's very difficult actually to find a consensus on. But that work is ongoing. Council on General Affairs and Policy, which is our governing body, this year again, asked for the working group actually to be established, to be upgraded from an experts group to a working group to continue this work. The other ongoing work is on jurisdiction. We still call it the jurisdiction working group because it's supposed to be the extension of the work on the Choice of Court Convention, the Judgments Convention, and now, the missing element is the jurisdiction element. So criteria to establish direct jurisdiction for courts in international commercial or civil or commercial situations. Truth be told, and now I would apply Chatham rules, and I don't want to be quoted on this, but I still think it will not be possible to find a consensus-based solution to establish direct grounds of jurisdiction, because the differences amongst legal systems are such that we have tried in the past, we did not succeed. I don't see what might have changed in the meantime for us to succeed. So that's why this project has taken a slightly different direction. And the working group deals much more effectively now with parallel proceedings and joint actions. This is something that happens very often in practice, that really irritates courts, because the same case is pending before a number of courts. So what to do in these cases, that will be and is currently the main focus of that particular project. Truth be told, the US in particular also pushes to still keep jurisdiction and the EU actually also to some, sorry, not the US, the EU pushes for jurisdiction still to be at least on paper for this project. But I don't see that happen. But something for parallel proceedings and joint actions is something that would be extremely helpful. We have just gotten a mandate to work on the law applicable to digital assets and tokens. That is a joint project with UNIDROIT. They had started already work on this topic. We are now dealing with the private national law aspects more specifically. A very exciting, important topic to work on. We will be asking at our next council meeting in March 2024 for another mandate to work on private and national law aspects relating to carbon credit trading. In particular, also in relation to the question as to what these carbon credits actually are. Because when you buy a carbon credit, you actually don't know what you actually buy. Is it a contractual right, a proprietary right? Is it a sui generis right? Is it a mix of all the above? So the same questions that we addressed in the past in relation to book entry securities or intermediated securities, so basically digitally held securities, now arise in the context of carbon credits. So we'll do that. There will hopefully still be more work also in the field of insolvency. IP, we tried quite a bit, in particular also in cooperation with WIPO, but there is some resistance amongst our members to be involved in IP work and to leave that field to WIPO. That's fine with me. We have enough to deal with. But these, in a nutshell, I think are the projects that we have in the pipeline.
Thank you, Pa. The last one is about cost-benefit analysis of HCCH membership. I mean, the panel have talked at length about membership. So perhaps I just for the last time, if there's anyone who has any additional comment on that, otherwise.
Okay, well, thank you. Maybe it's not exactly on the cost and benefit, but I just want to add the one that mentioned by Pak Penarsconi. Yes, we got support from the Supreme Court. The Supreme Court proposes 4 convention. 2 of them is coming from the HCCH convention. So let's see how the executive part would follow up this support from the Supreme Court. On the argument, Chatham Masru, I'm not to be quoted, but there was a pragmatic argument that why should we, if even when we are not a member, we can still get the benefit by ratifying the conventions. So, well, there are several arguments, but this is a thing that I can say. But again, Chatham Masru, thank you.
Thank you, Pa Amrin, and thank you everyone in the panel for, I think, a very interactive, insightful session. I'm sure that some of you in this room probably actually have more questions. I guess you can pose it to these panelists during lunch. And with that, I return the proceedings back to the MCs.
Thank you, Pa. Thank you so much.
We would like to express our greatest gratitude to Mr. John Lumbentobing for becoming the moderator of today's event. And we would like to thank all the speakers and participants that have participated in today's conference.
Next, as a form of appreciation for our speakers, there is a handing over a plaque that shall be done by the Dean of the Faculty of Law of Parahyangan Catholic University, Mr. Dr. Yurliona Nanang Supriyatna, Bachelor of Law, Master of Humanities.
The plaque will be given to all speakers, and the first speaker that will be given the plaque is Mr. Christoph Bernasconi as the General Secretary of HCCH.
Danke voor Ihre Vortrag und Ihre Aufklärung.
Vielen herzlichen Dank, Professor Knut.
Oh. Ja. Dankeschön.
The second plaque will be given to Mr. L. Amri Jinangkung as the General Director of Legal Affairs and International Treaty of the Ministry of Foreign Affairs of Republic of Indonesia. The third plaque will be given to Professor Budiono Kusumohamijoyo as a practicing corporate and commercial legal consultant and professor in the philosophy of law. The next plaque will be given to Mr. Bayu Seto Harjowahono as the chairman of APPI HPI and a private international law expert.
Next, we will hold a photo session together. We would like to kindly remind all participants to get ready.
For all the participants on the left side of the room and on the right side of the room, please can we all jumble up together in the middle so everyone can get inside the picture? For the speakers and the moderators, you may sit at the front of the room. Yeah, I think that. Iya, ngadep ke sini, Pak. Jadinya di sini. Ya, Pak, di tengah duduk dulu.
For the participant on left and right, we can gather together at the middle so everyone can get the picture together.
For all participants on the left side and the right side of the room, please gather in the middle so everyone can fit inside the picture. Thank you very much.
Okay. I will start the countdown. 1, 2, 3, and cheese. Okay, once again. Oh, okay. 1, 2, and 3, cheese. Okay, thank you very much.
Thank you very much. Before we finish today's our first session for today, I'd like to remind all participants to please scan the QR code in the front of the room in the projector so that we can gather the data for the participants in this conference. And now we have finished the first session of today's conference. Next, we will be having a recess before heading into the next session. For this recess, all participants may use the time for lunch break. The next session will begin at 1 p.m.
Before we finish this session, we, as the Master of Ceremony for today's conference, would like to thank everyone for their attention and would like to apologize for any and all of shortcomings. Thank you and good day.
The place for the lunch is behind this very room on this floor. And for the people that want to pray, there is a prayer room at the second floor of this building. Thank you very much. 2A, on the floor 2A of this building. 1 p.m. 1 p.m.
Bagi para peserta, untuk makan siangnya akan dilaksanakan di bagian belakang.
Bagi peserta yang ingin bersembayang juga ada ruangan di lantai 2A di gedung ini. Baik, terima kasih.
Udah, beres.
Udah.
Iya kan? Iya masih. Oh ya belum. Masih satu lagi.
Ya, pasti aja Pak Don.